United States versus Rahimi, a new United States Supreme Court decision just came out, and unfortunately, not only do we have the anticipated bad outcome that I was fearing, but the way it is written can actually have ramifications that go so much further against the Second Amendment. Guys, let's get into it. So you have two clues right away that a Second Amendment case in the United States Supreme Court is not turning out well. One, Justice Clarence Thomas is the lone dissenting opinion. And two is something that you encounter very quickly in the case, a line that goes by the fact of, quote, "The government offers ample evidence that the Second Amendment permits such individuals to be disarmed," end quote. I don't know which one's more cringy. And I want to make it clear that I'm covering this decision and I'm explaining it, but don't direct your wrath at me. I'm just explaining it. So on its surface, what we're talking about here is the federal prohibition against folks with a domestic abuse injunction against them, so a restraining order from being able to possess firearms. Now, if you're like most people, you're saying, it doesn't really apply to me. Why do I care? Believe me, you're going to care based on how they wrote the decision, and you're probably not going to like it. So be sure to stick through this whole thing. I condensed so much into this. I took the time to read the decision before making this video, so this is not fluff. Here's one of the concluding quotes that I think sums up what they do, not how they get there. Quote, "When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment." A lot to unpack there, but before we do, we're going to return to that. I want to go through the legal framework, what was some of their issues with how they got to their ruling, and then we're going to return to that concluding statement. First, the legal framework. Okay, so how is the court to decide whether or not a law that perhaps infringes on the Second Amendment is to be found constitutional or unconstitutional? This comes from the June of 2022 United States Supreme Court decision, the Bruen decision, B-R-U-E-N, for those of you on your lawnmowers, which basically said that when a firearm regulation is challenged under the Second Amendment, the government must show that the restriction is consistent with the nation's historical tradition of firearm regulation. A court must determine whether the new law is relevantly similar, those are some of the magic words, relevantly similar, to laws that our tradition is understood to permit, applying faithfully, these are some of the words of the court, the balance struck by the founding generation to modern circumstances. Why and how the regulation burdens the right are central to this determination. As the Bruen Court explained back in 2022, a challenged regulation that does not precisely match its historical precursors may still be analogous enough to pass constitutional muster. And that's where this is going to wind up going. Before we get there, guys, really quickly, I've got so many videos that I'm going to be doing in depth on this case, including blowing up all the internals of what's going on here, because this video is just a summary overview. We're going to be doing a whole video on Justice Clarence Thomas's lone dissenting opinion about what he said. We're going to be talking about dangerous and unusual weapons law and history, because that comes up in this case, red flag laws, along with so much more. So be sure to like, subscribe, and let me know in the comment section below what order you want to see those videos come out, or if one or two of them are maybe much more important to you, as well as where do you think the aftermath of this decision is going to be going, both legally and politically in our, of course, hypercharged election year environment. Okay, so finally, we have the Bruen history and tradition test now being done by the United States Supreme Court. This is so important because there's been so many questions out there about, okay, so what part of our history and tradition are we allowed to be looking at? Are we allowed to be looking at the 1990s? Do we have to go back to 1791 when the Second Amendment was codified and adopted? Is this something that we're looking at for the early founding era, say up to 1820s, 1830s, or can we go into Reconstruction era and beyond 1860s, 1870s, early 1900s, you name it? How representative does our example of regulation have to be in order for it to be ruled as, yeah, this is good enough? Does something have to be a direct historical twin, or can it be an analog, a cousin of sorts? And if so, how closely or distantly related can that cousin basically be? Those are all the huge questions that were left after the June of 2022 Brune decision. So being able to see the U.S. Supreme Court go through the analysis itself is going to be extremely important, independent of whatever conclusion the court reaches this analysis, because we'll be able to see how narrow or wide did they go. Okay, so that's going to be incredibly important here. Pay attention to that, because that's what's going to be going so much further than if you've been hit with a domestic abuse injunction, are you good or are you not good? So the court starts off by vaguely alluding to something called the Statute of Northampton, something we've talked about quite a bit here from time to time, which goes back to 1328 England, before then detouring to a specific law found in the post-Civil War England. Civil War England was 1640s. We're talking about the Militia Act of 1662, and then later, of course, the Glorious Revolution coming up in the later 1680s. They do this to basically build up to the point that, look, in England, historically, people could be disarmed for one of a few reasons. And the two that the court is actually focusing on here is whether those individuals were basically known or could be proven to be dangerous, and B, whether or not they were political opponents of the regime. Now, by the time that the Second Amendment was founded in America, 1791, the court says that basically our laws in America really only focus on people who are dangerous and not so much political opponents. I suspect a lot of people may disagree with that. 1911 Sullivan Law comes to mind, targeting a lot of folks in New York City, but hey, different story for another day. The court comments that by the 1700s to early 1800s, though, two distinct legal regimes had developed that specifically addressed firearm violence. Again, this is what the court's saying, not what Tom Grieve is saying. One is the Surety Laws, and I'm going to talk about that, but the Surety Laws and the so-called Going Armed Laws, where the Surety Laws were basically treated as preventatives to prevent violence. The Going Armed Laws were largely punitive for a pre-existing infraction. So someone does something, now they're going to be subject to the Going Armed Laws, basically like a criminal law. So let's take a quick look at these two. The Surety Laws were a form of so-called preventative justice, which authorized judges and magistrates to require individuals suspected of future misbehavior to post a bond. So this is almost like probation, but of course on probation you have to be convicted of a crime to go on probation. Here you don't have to be convicted of anything. If an individual failed to post the bond, he would be jailed. If the individual did post the bond and then broke the peace, the bond would be forfeit. Surety laws could be raised and invoked to prevent all forms of violence, including spousal abuse, and also targeted the misuse of firearms, according to the United States Supreme Court. We're going to take a look at one of those laws here. These laws often offered the accused significant procedural protections, and that's important in the eyes of the Supreme Court. These aren't just arbitrary decisions with no due process. There has to be some significant procedural protections. More on that in a bit. So the court points to the 1795 Massachusetts law, which basically authorized judges of the peace to arrest all who go armed offensively and require of the offender to find sureties for his keeping the peace. So all who go armed offensively and require of the offender to find sureties for his keeping the peace. So it sounds like you have to have done something in order to be deemed to be a future threat. Kind of feels like probation again, because you have to basically be proven guilty to some degree or another, right? Well, later Massachusetts amended its surety laws to be even more specific in the court's view. They went on to authorize the imposition of bonds from individuals who, quote, went armed with a dirk, dagger, sword, pistol, or other offensive and dangerous weapon, end quote. So again, this feels like you have to have done something in order to get something. It feels like there's almost a probationary element to it here that the court is escaping. But of course, that gets us to the question, how did you get put on a surety? Someone or maybe a group of individuals makes a complaint to a judge back in the day. The judge listens to the evidence and decides, and you're not there when this is happening, if there's enough to basically summon the respondent. That's the person who's accused and maybe ultimately put on that surety. If there was not enough in order to get the judge to say, yeah, this could be a thing, then the case is over and dismissed, and maybe the respondent never even finds out about it. If there was enough in the view of the judge, well, then the accused would be summoned to provide a defense if they chose. Bonds could not be required for more than 6 months at a time, and an individual could obtain an exception if he needed his arms for self-defense or some other, quote, legitimate reason. So obviously we have some major distinctions here, because sometimes domestic abuse injunctions can last a lifetime. Rarely are they 6 months. They typically go in the years, so we have some time frame issues, not to mention the fact that in my years, both as a state prosecutor and as a defense attorney, I see judges practice the defensive practice of law, whereby if an individual comes into court and basically says the magic words of, "I'm afraid and he has guns," low resolution right now, very commonly rubber stamp, done, off you go, and those can be often renewed, rubber stamp renewed, after the expiration in 2 years, 3 years, 4 years, whatever it may be. These are all major loopholes that I'm concerned about in this decision. The going armed laws, so we just covered surety, now this is the going armed laws, are a particular subset of the common law prohibition on so-called affrays, AFFRAYS, or basically kind of things like fighting in public. You're basically providing a mechanism for going after and punishing people who have menaced others physically, with firearms, you name it. Now, under these laws, individuals were prohibited, according to the famous English jurist Blackstone, from, quote, riding or going armed with dangerous or unusual weapons to terrify the good people of the land, end quote. Those who did so faced forfeiture of their firearms as well as possible imprisonment. Prohibitions on going armed were incorporated into American jurisprudence through common law, and some states who expressly wrote them into their state law. Now, it's worth reminding you that up until 2010, the Second Amendment did not stop the states from infringing on the Second Amendment principles. So pointing to what states did, whether it's 200 years ago, whether it's more recently, up until 2010, there's a taint on them, because unless the state constitution passed something directly analogous to the Second Amendment, there were no firearm rights. There were no Second Amendment rights to be armed, to purchase arms, to so forth. Because up until 2010, the Second Amendment had not been incorporated against the states. It only restricted the federal government. Now, together, the Supreme Court says that the surety and the going armed laws confirm what, in their view, common sense suggests, that when an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. And then, of course, the court makes the leap we all know that they're going to be making if you've been reading the decision, which is linked in the description box below, that, hey, like the surety laws and the so-called going armed laws, the domestic abuse injunction statute at 18 U.S.C. section 922, sub G, sub C, sub 1, applies to individuals found by a court to threaten the physical safety of another. This prohibition is, in their view, relevantly similar to those founding era regimes in both why and the how it burdens the Second Amendment. Now, the court does go on to make clear in the decision that you cannot just categorically disarm groups of people, but instead only individuals after court has found that the defendant represents a credible threat to the physical safety of another. Okay, so there's a list of good and bad that comes out of this. One is, of course, the affirmation of something that I've been warning people about for months now. Bad facts make bad law. Rahimi, not a good guy. I've covered him in details elsewhere. Won't repeat it here. Not a good guy. Just not a good guy. Bad facts make bad law. When his case got accepted to the U.S. Supreme Court, myself, and I'm sure others as well, I know others as well, sent up the warning flags of this is not good. Now, on the good news front, this decision could have been much more expansive. We could have been looking at categories of felons and all this other kind of stuff as to whether or not somebody who maybe wrote a bad check when they were 20 and they're now a convicted felon and now they're 60, are they still prohibited from possessing firearms? The court didn't extend this analysis. They focused exclusively on the federal statute dealing with folks who are under a qualifying domestic abuse injunction. However, the language and the mode and the method and the road that they used to get there is a little scary, because on the bad news side, we had persisting questions from the Brune decision about how close does a new law or regulation have to be to a historical law or precedent in order for it to be close enough. And the court frankly widened that a little bit more than I would prefer, and that's a gentle understatement. That's some bad news. They leapt from surety laws, which admittedly, yes, they are dealing with firearms, but there's a lot of dissimilarities between the two here. And they said, yeah, good enough, or in their case, relevantly similar enough. That's scary. Something on the good side, the court also basically addressed explicitly some of the government's arguments about the Second Amendment only being for responsible people, all this responsible language, which, to be fair, the court did kind of set up because they used some of those words in Heller and Brune, although as the court made it clear, those were not canonical terms where only responsible people, because whatever the heck that meant, it wasn't defined in those cases. The court said, no, enough with this. Another bad thing is red flag laws. This seems to all but open up the floodgates for red flag laws. They seem to be coming now as long as the states basically tailor them to give folks enough due process and they're not permanent. We seem to be in a position where the Supreme Court just threw open the door and invited them in. So guys, I want to be clear. I knew this ruling was going to be rough. It was the one I circled of all the current U.S. Supreme Court cases dealing with the Second Amendment that I was most worried about. Bad news, it's a little rough. It is. It opens things up for some floodgates. It invites in red flag laws. The good news is that while not good, this could have been much, much worse. They could have opened this up for so many more things. They could have chosen things from, for instance, the last 20 years as being representative of American history and tradition. They could have gone for even more loose analogies. And no, I'm not trying to find the silver lining in this. I'm just calling it like I see it. This is not good, but it could have been so much worse. And I think that this is going to continue to set up the battlefield for, of course, the many legal confrontations yet to be fought when it comes to so-called gun control, i.e. civilian disarmament, and the future. So before I get to the quote of the day, be sure to hit that like button if you made it this far. Let me know in the comment field below, what do you think about all of this? Where is this all going, and what videos do you want to see fast-track and prioritize? We appreciate you sticking around to the end. Here's our quote of the day. It comes from Mr. John Adams, quote, "Defeat appears to me preferable to total inaction. We can never suffer from inaction in defense of our liberties, folks." That last part's me. I appreciate you sticking around. We'll see you in the next video. I'll see you in the discussion below. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.